The Santa Clara County Public Defender's Office. We are your voice. We welcome you to the Santa Clara County Public Defender's Office. Being arrested and charged with a crime can be one of the most frightening and intimidating experiences an individual or family can face. Our goal is to provide quality legal representation to individuals who face criminal charges in adult and juvenile justice court. We represent clients in cases ranging from misdemeanors to capital murder. We also represent individuals in civil mental health proceedings. We are honored to do so. Each person referred to us has a unique case. Some are falsely accused and seek vindication. Some suffer from mental illness or struggle with addiction and need services to address these burdens. Some of our clients are youth in trouble who, regardless of the truth of the charges against them, need every resource we can obtain to live the good lives they deserve. Whatever our client's circumstance, we are dedicated to providing each individual a voice in the courts and to seek justice and the best possible outcome in every case. The Public Defender's Office is comprised of over 200 employees, including well over 100 experienced attorneys, all committed to providing quality legal representation for you. Every single lawyer in the Public Defender's Office has attended law school and is licensed in California. Our attorneys are excellent lawyers with vast trial experience. Your defense team will also include experienced investigators and paralegals, a research department, and access to experts who can potentially testify on your behalf. If you are charged with a crime in Santa Clara County and you cannot afford to hire your own attorney, we want to represent you. Your first court appearance is called an arraignment. This is the first time that you will be told by the court what your charges are. The judge will ask you if you would like a public defender. You should always say yes. Before we can proceed on your case, you will have an intake interview. You will meet with a paralegal who will ask you some personal information and will then listen to your side of the story. It is important that you share with the paralegal whether you are a veteran or have immigration issues, whether you have prior convictions and/or are on probation or parole, and any mental health history you may have. This interview is private and confidential. Everything you say is held in the strictest confidence. Even your family and friends will be asked to remain outside to preserve confidentiality. It is critical that you are honest so we can prepare your case effectively. Between arraignment and a trial date, you may have several court dates with different attorneys who specialize in different phases of the criminal justice process. They work from your same personalized file and share information about your case with each other. The court dates leading up to an actual trial date can consist of various legal proceedings. We will explain to you the different court dates you may be attending. At some point, your attorney may request a continuance in your case. This allows your team of lawyers, paralegals, and investigators to fully investigate the facts, file necessary motions, and engage in pretrial settlement negotiations. You will have several opportunities to settle your case before trial if you wish to do so. Your attorney will meet with the judge and the prosecutor to negotiate a settlement offer. If you do not wish to settle your misdemeanor case, we will set it for trial. If you choose not to settle your felony case, it will likely be set for a preliminary hearing. A preliminary hearing is your first opportunity to officially see the evidence against you. Your attorney will be able to cross-examine the police officers or other witnesses that may be called to testify against you. A preliminary hearing is not a trial. It is simply a hearing where a judge will determine whether there is enough evidence against you to proceed to trial. Prior to trial, your attorney will determine whether legal motions are appropriate in your case. Whether you are charged with a misdemeanor or a felony, you have a right to a speedy trial if you choose to have a trial. If you set your case for a jury trial, 12 people from the community will listen to the evidence and decide whether you are guilty or not guilty. In a jury trial, all 12 people must agree on a verdict for it to be final. The Public Defender's Office also represents minors in the juvenile court system. The terminology is different from adult court, but you still have many of the same important constitutional protections. You may first have a detention hearing to determine whether or not you should stay in juvenile hall. Next, your case will be set for a pretrial conference that is called a jurisdictional hearing. If your case settles, the judge will determine your sentence, which in juvenile court is called a disposition. If you want to contest your charges, you will have a contested jurisdictional hearing in front of a judge. The judge will hear the evidence and decide whether the charges are true or not true. If you admit the charges are true but disagree with the sentence or disposition to be imposed, you can have a contested dispositional hearing in front of the judge. This lets you challenge probation's recommendation regarding what should happen as a result of your charges. Whether you are an adult or a minor who has been arrested and is facing criminal charges, the Public Defender's Office is here to help. Our attorneys are experienced at making sure that your constitutional and legal rights are protected. We will provide you quality representation and will ensure that you receive the best possible defense. We are the Santa Clara County Public Defender's Office, and we are here to help.